The first matter to come before the court this morning is State of Ohio versus Jennifer White. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. Please don't use the names of any victims or minors. I don't think that's a problem in this case, but we are live streaming and recording this oral argument to be placed on YouTube later. If you're the appellant and you wish to reserve time, if you let me know when you get started, I'm keeping the clock and can let you know when you're getting close to or into any reserved rebuttal time, excuse me. The court has read the briefs. We are ready to proceed when you are.
Thank you, Your Honors. May it please the court. My name is Brian Smith. I'm here on behalf of the appellant Jennifer White. I'd like to reserve 5 minutes for rebuttal. Your Honors, there were 3 assignments of error raised in this case. I'd like to touch briefly first on the manifest weight issue. One of the main issues, this case turned greatly on the reliability of the Python radar unit that was used in this case. The state cited the case Brook Park versus Rodiev in its support of its argument that the radar was shown to be scientifically reliable. The ruling in Rodiev was narrower than what the state cited it for. The state needs to show the reliability of the type of the device, not just an individual unit. What happened in the ruling in Rodiev centered on basically said that the state doesn't need to prove doesn't need testimony to show the scientific reliability of radar itself as a scientific principle, or LiDAR itself as a scientific principle. What our objection is here is based on the specific device, not the scientific principle itself. And I think that's an important distinction to make here, that the ruling was not quite did not deal with the specific type of device that we're looking at in this case. Now, as far as the there were also some issues with the trooper specific qualifications. There was some testimony about the trooper's history. He had been employed with the Highway Patrol for about 21 years. He had done his training, his initial training back in, I believe it was 2000 or 2001. However, there were no the state did not show that he had qualification on this particular device, on the MPH Python 2. It also showed he had not taken any refresher courses since 2016. So I think that shows there's kind of a gap in time that shows there's an issue with using this particular unit. And
aren't your arguments based on sufficiency? I mean, Ridojev basically said those results can come in, correct? But it left open the door to challenge on sufficiency, such things as the calibration and maintenance of the device, perhaps how it was held by the officer, and the qualifications of the officer for using the device. Aren't those sufficiency arguments?
Your Honor, technically it's a manifest weight issue, because once the defense objected to the device coming in, the trooper gave a visual. He testified that he gave a visual. Did a visual estimate of the speed. So our argument would be it's more of a manifest weight as far as was the evidence shown sufficient to show that the defendant was operating a vehicle at 75 miles an hour.
One quick question on the visual estimate. The officer gave an opinion as to the speed. Did he also testify as to training and experience concerning estimating the rate of speed on cars and moving objects? Was that part of his testimony?
He did, Your Honor. He testified. He did testify a bit as to the visual estimate. However, we would submit that the visual estimate was unreliable here, because his testimony was that he, as far as his training to do visual estimates, was only his basically his initial training when he joined the Highway Patrol, which was about 20 years ago, 20 years prior to that. So there was no testimony as to refresher courses or anything akin to CLEs for highway patrol troopers that would kind of supplement that training that he had received when he joined the Highway Patrol. And I would also
thank you.
Oh, I'm sorry. Was there a follow-up?
No, I said thank you. I don't mean to interrupt your argument here.
Counsel, I do have a question for you, as long as we're talking about the case law. What is the response to the state's argument that what you are arguing is basically what is found in Justice Kennedy's dissent?
Well, I would say that I would say that as far as that goes, I mean, our argument centers on the applicability of the Brook Park versus Rodiev holding. I mean, as far as the dissent goes, I mean, obviously a dissent is not a majority opinion. Today's dissent can be tomorrow's majority opinion. So I think that's, that's one of those axioms that you hear from time to time. But as far as the reliability of the device, that's the state has to show that particular device was reliable. And I think that's where the case comes up short, because there was no testimony as to that. Now, the court did take judicial notice of that. However, the defense objected to that, and the problem with there is there were two cases that the state cited as far as judicial notice was Rodiev and State versus Young out of Wayne County, which is a case out of Wayne County. The problem was, though, Young was not a reported decision, and this court has held in State versus Mico that you have to have a reported decision in order to serve as the basis for judicial notice. And I think that's another problem here was, first of all, that Rodiev's not on point as to what the state's trying to use it for to show the reliability of this particular device. And second, that they relied on State versus Young, which is not a reported decision.
Well, I think the state concedes, and they can correct me when their turn comes, but I think the state concedes that the trial court did not take judicial notice properly, but that Rodiev is makes it harmless error. So I guess the argument there has been conceded regarding the judicial notice. I understand what remains on behalf of your client, Mr. Smith, but I don't think we have an argument when it comes to judicial notice here.
I understand, Your Honor. And again, we would just point out the holding in Rodiev is not applicable to this particular fact pattern. Rodiev dealt with testimony not being needed as to the scientific principles of radar and LIDAR. And our argument's not centered on, we're not attacking the scientific principle itself. We're looking at the reliability of this particular device. And in this particular case, the state did not meet its burden to show that device was scientifically reliable for the purpose of measuring the appellant's speed.
Could I ask you a question? I'm sorry.
Oh, no.
I just was wondering, I think I understand your argument, but I guess I'm wondering, does the actual speed really matter if your client was speeding?
It does, Your Honor, because the citation stated that she was traveling at 75 miles an hour. So at that point, the burden is on the state to show that she's guilty of operating at a speed of 75 miles an hour. So even if the trooper gives a visual estimate and says, I think she was going over 55, or I think she was going over 60, that in and of itself is not, it's competent evidence to show to point toward that, but it's not enough to show that particular speed. So in this particular case, the state had to rely on, if the state doesn't have a scientifically reliable reading from the Python 2, they can't show that she was speeding at 75 miles an hour. Now he can give a visual estimate and maybe be between, visual estimates are, any law enforcement officer will tell you visual estimates aren't meant to be that precise, and which is why they use these machines in order to calculate the exact speed. So that's really what it comes down to. And there's an injury here because she was assessed points for being more than 10 miles over the speed limit. So that's really what the issue comes down to.
Okay, well, I guess the reason I was wondering is because your client is not contesting the fact that she was speeding.
She did testify, Your Honor. I believe she indicated that she had looked at her speedometer and she was at, I believe her testimony was she was at 64. And this was on the stretch of US 30 in Wayne County where the speed limit is 60. Mm-hmm. So there was so yes, she did admit that she was, according to her testimony, she was over. However, it does make a difference as far as, because the state charged her with going 75 in a 60 versus 64 in a 60. And it does, again, make a difference as to the points on her driving record, because had she been found guilty of 64 in a 60 or some lesser than 10 mile an hour speed, she would not have been assessed points.
And counsel, you have about 4.5 minutes remaining, so you're a little bit into that rebuttal time at this point.
Okay, I'd like to reserve the remainder of my time for rebuttal, and we ask that the court reverse or remand. Thank you.
Thank you, counsel.
Judge Hensel, can I my pen ran out of ink and I'm taking some notes here. I'll be right with you.
Sure, I won't start the clock yet.
Okay, thank you.
Counsel for the state? We're ready to proceed when you are.
Thank you, Your Honors. Good morning, and may it please the court. I would like to just clarify, Judge Hensel, you are correct. The state has conceded both assignments of error 2 and 3. Judicial notice was not taken properly, and the records concerning the calibration checks that the state sought to admit at trial and did successfully admit at trial should not have been permitted under that hearsay exception. And so the state does concede assignments of error 2 and 3. So what we're really left here with is the application of Rodiev. And the state would also note that the trial court, there was some testimony regarding a previous issue or previous work order with the radar device in question. The trial court properly disregarded all of that testimony as hearsay, as noted in their oral decision transcript, page 75. So what we're left with is the trooper's testimony regarding the accuracy and manipulation of the Python 2 in question. The trooper top testified that he'd been a trooper since 1999 when he went to the academy. He testified at great length regarding his training on multiple radar devices, including the MPH Python 2, which he initially received training on in 2000. That was on page 7 of the transcript. He then went into a great detailed explanation of exactly how the MPH2 is operated, to include all of the functions checks and tuning fork checks that are conducted on a shiftly basis to ensure that the radar device is in fact working properly, and that those checks are done in accordance with the training that they receive on that device. As I believe was already noted in questioning by Judge Hensel, the Rodiev decision, Justice Kennedy in the dissent, indicates that this is the exact type of challenge that is precluded by the majority opinion. What we're left with, as Judge Teodosio noted, are challenges to the functioning of the device on the day in question, not whether or not that device itself is reliable based on its production. It's whether it's functioning properly on the date in question. So Trooper Top testified, again, pages 7 through 9 of the transcript, in great detail as to the functions checks, both the internal functions checks of the device, what they refer to colloquially as the light check, where the system runs an internal calibration check. He then testified as to the tuning fork checks that they run at a minimum at the beginning and end of every shift. They run them at the beginning of every shift and then typically after each traffic stop. Trooper Top testified that he conducted these checks in accordance with his training, and that there were no malfunctions noted, either prior to or after the stop on Miss White. He further testified that a visual inspection of the components of the radar device did not reveal any any physical deformities, if you will. Now, counsel for the appellant objected to Trooper Top's ability to determine whether or not the device was functioning properly, if there's anything physically wrong with it, but that testimony just goes to any physically observable malformities or deficiencies to the device. If there was any noticeable dings or pieces missing, any wires that were showing visible signs of deterioration. An inspection of the tuning forks that are used to conduct the checks revealed no nicks in the metal, of that sort. So I do believe that there is more than sufficient testimony on the part of Trooper Top that the device was in working order. So it comes down to whether or not the trial court found his testimony to be credible. And I would note that on redirect, Trooper Top further bolstered that credibility going into the training that he has had on the MPH Python 2. I would also note that he testified on page 7 again that he was initially trained on the Python 2 in the summer of 2000, that he's consistently used that model of device since that point. In appellant's brief, appellant noted that the defendant testified that the device that he was using on the date in question was different than the MPH2 that he was trained on in 2000. And I would respectfully submit to the court that that is an incorrect statement of the testimony. On pages 42 to 44 of the transcript, Trooper Top on redirect testified as to the differences in the successive versions of the MPH, the original MPH, the Python 2 and the Python 3, which he noted that the State Highway Patrol Post does not even have, that he has been using the MPH2 successively since 2000 when he was originally trained on it. I would also take note with the characterization in appellant's brief that the Trooper Top did not have any training, remedial training or concurrent training on the MPH2 since 2016. He repeatedly rebutted that on cross-examination, stating that he had received training every 2 to 3 years on the different devices. The notion that their argument that the trooper's testimony regarding a visual estimation came after an objection and somehow that reduces the credibility, I don't think that that should hold any weight with this court. Trial counsel did fail to inquire into the trooper's training on visual estimation at the point when he elicited the background testimony, but the trooper testified in narrative that in describing the stop that he first made a visual estimation of the defendant's speed to be in excess of 70 miles per hour. trial counsel for the state then followed up to elaborate on that to ensure that the trooper had in fact been trained on the visual estimation of speed, and he detailed how that training was conducted by going out during the academy back in 1999, going out and getting assessed by a trainer on his ability to accurately determine the speed of a vehicle. He then further, well, I will concede he did not testify as to any continuing education or remedial education on the visual estimation of speed, but he did testify that as a sergeant with 21 years of experience in the Ohio State Patrol, that he has relied on the visual estimation of speed in accordance with and in conjunction with the use of radar over the course of his career in law enforcement. So I think that this comes down to a assessment of credibility, which the trial court obviously found the trooper's testimony to be credible regarding both his competency in manipulating the device on the date in question and that the device in question was properly working. Now, I just want to go
Also,
back.
let me interrupt you. I want to ask you the same question I asked Mr. Smith, and that is, as the state, since you indicated, since the trooper indicated that she was traveling 75 miles an hour in the complaint, do you as the state have to prove the exact amount of speed?
Your Honor, I'm going to be honest, and since that was not raised in brief, I'm not prepared to give a definitive answer to that. Based on just a reading of the statute, I could honestly see arguments to go either way, because the statute reads a vehicle traveling in excess of 60 miles per hour, but then I can also see where a defendant who is facing points due to a higher speed would have an argument that the higher speed must be proven. So I would not make a strenuous argument to that either way. Okay,
I was just wondering because what the significance of the defendant actually testifying and admitting she was speeding.
Yes, Your Honor, again, that is something that perhaps we should have raised in response in brief, but since it was not argued in brief, I did not prepare for that argument today.
Thank you.
Thank you, Your Honor. I would like to just return to the analysis of Rodiev and its applicability to this matter. I think that adopting the interpretation that the appellant urges you to adopt today would effectively gut Rodiev until such time as the different radar and LiDAR devices are been proven in accordance with evidence rule 201. It is exactly the type of testimony that Rodiev was intended to do away with. And Justice Kennedy obviously disagreed with that, and I can understand any practitioner of law or any justice having issues philosophically with the majority's holding in Rodiev, but I think that the presentation of the dissent makes it very clear what the majority's holding was intended to do. As Judge Teodosio noted, the majority makes it clear that the challenges that are now acceptable go to the functioning of the device in question, and that is a matter for the trial court to assess the significance, the amount of weight that it gives to the evidence. And I think if the court reviews the transcript in length, specifically the portions that I've highlighted for you, and then looks at the trial court's decision on pages 75 and 76 of the transcript, you'll find that she did properly weigh all of the factors and all of the evidence before the court that was properly admitted. I would agree. I would argue that, as I stated, assignments of error 2 and 3 being conceded, that the admission of those records under assignment of error 3 are harmless error because the trooper's testimony was so convincing. I would also note that the appellant in taking the stand, did, when she admitted that she was speeding, she did so at a level that did prevent her from getting the points. And as was elicited on cross-examination of the defendant, that she has a motive to do so because she was, at the time at least, acting as a delivery person for a living. And so there was credibility issues there that I believe that the trial court properly weighed with the trooper's testimony. The last thing that I would just like to note is that the trooper did, in fact, testify repeatedly to and consistently that he had been trained on the Python 2 and used it over the course of time. And then I did want to note there was some discussion about the defendant's testimony and the fact that she was traveling at 64 miles an hour. She testified that she was decreasing her speed at that point because she saw that, I believe because she saw the trooper, but I might be mistaken on that, but she did testify that her speed was decreasing. And that would actually coincide with the readings that the trooper testified that he observed on the radar unit, starting out at 78, 77, and then 75, which was the speed that he eventually cited her for. I don't think that there is any evidence before the court to contradict any of the trooper's testimony other than the defendant's statement that she was traveling at 64 miles per hour. I don't believe that there's any testimony to draw into question the accuracy on the device and the date in question. And I certainly don't think that there's any legitimate question as to the trooper's training and experience over the course of the 21-year career. With that, Your Honors, I would respectfully submit to the court that the trial court correctly found in favor of the state that there was sufficient evidence under Rodiev for a finding beyond a reasonable doubt that the device was working properly and that the trooper was trained properly and qualified to handle it. And you know, given that this is a manifest weight, you know, given those facts, I don't think that the court should disturb that judgment. Thank you, Your Honors.
Thank you. Counsel for the appellant, you have 4 minutes and 30 seconds.
Thank you, Your Honors. I want to touch again on the Rodiev decision. Our argument is actually right within the parameters of Rodiev. The purpose of Rodiev was to not require the state to show the scientific reliability of radar or LiDAR itself. And that's not an issue in this case. What's at issue in this case is the reading from this and the reliability of this particular device. And in fact, the Supreme Court recovered this in the syllabus. I mean, it's the fact finder must still determine whether the evidence presented concerning the accuracy of the speed measuring device and the qualifications of the person who used it is sufficient to support a conviction based on the device's results. So again, the purpose of Rodiev is to limit prevent the state from having to call in an expert on every case to testify that radar itself or laser itself is reliable, not as far as the specific device. So our argument is right within the parameters of Rodiev. It would not disturb the Rodiev decision in any way, shape, or form. As far as the determination of the functionality, I don't see any reason to limit it to looking for visible defects in the machine at this point. Especially when you combine that with the trooper's testimony that he had about 20 years of experience as a trooper in the highway patrol up to that point. So at that point, if he sees something amiss or something awry, even if it's not a visible defect in the machine, he can testify to it if, according to the state's argument, he has experience on this particular device. As far as credibility issues go, I think credibility is kind of it's sort of there are issues with the troopers' credibility here too because of the lack of evidence showing training on this particular device. Even though he had some years of experience as a trooper on that particular device, and not being able to show any follow-up training as far as giving a visual estimate. So there were also issues with the trooper not being able to testify as to the calibration check that had been done on the machine. He did testify as to the check at the beginning of his shift, but not the semi-annual calibration check that was done in June of 2020 prior to this case. So I think there are some credibility issues with the trooper as well that I would argue at least offset or outweigh any possible credibility issues on behalf of the defendant or appellant in this case. So we would submit that that this is within Rodiev, that the state did not show enough evidence to show the scientific or to show the reliability of this particular device, that they still need to present evidence of the accuracy of this particular device as well as the qualifications of the person who used it, and that the state did not meet its burden in this case. And this renders the appellant's conviction against the manifest weight of the evidence. And I'd be happy to take any further questions from the court.
Seeing none, thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Have an excellent day, gentlemen.
Thank you, Your Honors.
Thank you, Your Honors.